Hi there, Jon Iannotti here, and tonight we're going to be talking about options. And I got John Roush with us here, one of our students, and also one of our other mentors, Chris Carroll. So we're going to start on all these documents, and man, there's a ton of them. I think there's about 11 things that you need to do an option our way. And one of the things that we want to start out with is, number one, is it's an option worksheet. And the option worksheet is basically, you fill in the blanks, you put in, the seller, his information, information about the property, about the loan, all that kind of information, so that you can take that back then and use the information to fill out your documents. So you have everything all in one place. The option agreement itself is a 4-page document that gives you the right to buy a property. You don't have to buy it. That's the beauty of it. In our business as real estate investors, the option to purchase real estate contract is the #1 tool in our belt. This is the document that we live and die by. Purchase and sale agreement, that's the one that's used by a realtor. Okay, now do we use a purchase and sale agreement? Yes. But the one there's two pieces of paper that really make it that we can do what we do legally, and that is #1, the option to purchase contract, and #2, the notice of real estate option agreement, or in some states it's also called a memorandum of option. The memorandum of option or notice of option is the one that is signed by the seller and by you and witnessed by a notary, and then the notice of option is then filed in the courthouse against the property, putting you in the chain of title, and it actually gives you an equitable interest in the property because you do give consideration to the seller to make the contract legal. And a lot of people say, what's consideration? Well, consideration can be anything, from $1 on up. Typically on our contracts, the ones we do, we use $10. Sometimes we use $100, depending on where we are. I mean, if we're working on a 7-digit property, we're going to give them $100 on that one. If we're $500,000 or below, I'm probably going to give them just $10. Once that is recorded in the courthouse, like I said, that gives you an equitable interest in the property, makes it legal for us to market and sell the property as a for sale by owner. So those two pieces of paper, the option and the notice of option, are the most powerful things that we have as investors, and it gives us the legal right to do what we do. If you do not file that notice of option, then you could be construed as acting as a realtor without a license, and that's one of the last things you want to do, because then the Attorney General starts knocking on your door. So keep that in mind. The option, notice of option, are your two most powerful documents. The #4 on our list is the as per legal description. Now, there's a 4th page on the option that is blank, and it's listed as per legal description Exhibit A. And what you do with that is, when you get the deed for the property, cut and paste the legal description from the deed directly onto that page, and you have the legal description on the contract exactly how it is recorded previously on the deed. you have to get it exact. I mean, if you leave out a comma or misspell something, then that is a technicality, and that can cause issues down the road for you and for title insurance. So you want to make sure you do it exactly right, and the best way to do is, if you have an electronic version of the deed, copy and paste the legal description straight onto that form. Down here in Florida, what we've been doing, and actually Chris has been doing a lot of these options, on the notice of option, instead of having the second page as Exhibit A, he's actually been able to get it onto the notice of option form, thus eliminating one extra page to pay recording fees for, right?
Yeah, I started doing that because I found out the deals we were doing in Florida, it was $10 to record the first page, $8 for every additional page. Not all states are like that. If you're doing deals in Pennsylvania, Ohio, a lot of those other states in the northern regions, they'll charge you a set fee, like Ohio's $28, and that covers your first 2 pages. So there it doesn't matter as much, but just because here we record so many options, it saves me $8 every time. So it just made sense to get the legal description right on that front page. But John's right. You got to make sure you get it word for word, because you don't want any misspellings or any words left out to get it put on or reported to the wrong property. So it's got to be exact.
Awesome. Okay, the next document that we also get from the seller to fill out and get it back to us is, and we actually use the FARBAR, the Florida Association of Realtors, seller's real property disclosure statement, and it's everything that the seller knows about the property. They have to disclose it. Pennsylvania, we also use the Pennsylvania Association, Realtor Association, their form of seller disclosure also. But it's typically about 4 or 5 pages, depending on your state. Like I said, everything they know about the property, the mechanicals of it, if there's any homeowners associations, condo fees, that kind of stuff, anything like that, and they fill it out, and we get that back so that we can pass that on to any potential buyers that we have that come through our marketing. The next document is one that we use, the realtors use, and that is the agreement of sale, or the purchase and sale agreement. The agreement of sale or purchase and sale agreement then is entered into once we find that buyer. Now, if it's us and we're buying the property, it'll be us entering into the contract with the seller. But if we're doing an option and we're going to assign that option off to somebody else, then the contract, the agreement of sale, will be done with the buyer and the seller. So, and there again, just like in the option, the agreement of sale spells out the terms of the deal, and a lot of times, especially if there's lenders involved, they don't want to see an option. They want to see a purchase and sale agreement or an agreement of sale. So we also use that document on our deals with options. We have a form in our packet also. It's called Title Search. And basically what this is, and we've used this for a number of years with our girl who does our quick look at our titles for us. And she actually works for a title company. And what we do is, on that form, we put the date, that we're requesting it, the property address, county, school district, owners' names, all that kind of stuff. We fax that off to her, and she will go do what we call a quick look at the title. Now, a quick look at the title is when she's going to look at the title from today back to when they bought the property. The seller bought the property. It's just an overview. It's not an in-depth title search. It's just a quick look at it to see what has been added to the property as far as liens, judgments, taxes, that kind of stuff, since they've owned the property. Why do we do that? Because we want to know if there's anything attached to that property if we're going to get involved with the property. A lot of times the sellers will say, oh yeah, there's nothing, you know, I paid my mortgage off. And then we do a quick look at it, and we find there's 2-3 mortgages on there. Maybe there was a mortgage that was supposed to be paid off, or was paid off, but was never released. Taxes, maybe a judgment, whatever. So we want to know what we're getting involved in before we actually commit to the whole deal. And we do that once we've come to terms with the seller, and we're getting all the documents drawn up by the attorney to do the option and get the ball rolling. So we want to have her do the title search, or quick look at title, while we're getting everything started. She'll get back to us usually within 24 hours, and when that happens, then everything's a green light. We turn the attorneys loose. They draw up the documents, and then we go forward from there. Something else you really want to get signed and filled out is just one piece of paper. It's called an authorization to release lending information. Now what you want to do there is, this document, when we send this off to the lenders that hold the mortgage on the property, then that gives us permission to talk to them, because they won't talk to us without authorization from the sellers who are on the mortgage. And why do we do that? Because a lot of times the option that we take is that we're going to take over the debt. So we're going to take it subject to, we're going to take it over with a lease option, whatever. We still need to talk to the lender to find out, you know, what's owed on it, what's the payment, how much is, how long's the term, how many years are left, that kind of stuff. And who do we send the check to? So that they get their money every month. So that's a good document to get filled out also. Now I know Pennsylvania and Florida, and I'm sure just about every state out there, here again, check with your attorney, but there's a notice to the homeowner or seller that we get them to fill out. What this is, with any contract, there's a three-day right of rescission, and that's basically explaining to them that they do have 3 days to change their mind if they don't want to go into this contract with us. So that's another thing that you get filled out, and it gives you 3 days to get your quick look at your title ordered, get that back, and once the 3 days are gone and they have not rescinded the contract, you turn the attorney loose to start drawing up the documents. We came up with a receipt of option consideration fee document. Now what this is, we just ran into this about a month ago. We had some people that we were doing short sales with that said they didn't get their option consideration, so that we didn't have a contract. So in order to make sure that everybody is on the same page and that we don't have any legal issues of them not getting the option consideration, we created this receipt of option consideration fee form, which basically states that when we fill this out, and we also made it that it gets notarized, so it's going to be filled out, signed in front of a notary, that they did receive the option consideration, and they acknowledge it, and they sign the paper in front of a notary, and we have that in the file as well. So that should eliminate any questions as to whether or not they received the option consideration fee. One of the last documents that we have in the file, and it's a 2-page document, and this is one of those CYA, cover your asset kind of documents, and it's a seller's acknowledgement form. And the seller's acknowledgement form it basically covers everything. I mean, it says that the seller acknowledges that they are the owner of the property, that they accept the terms and conditions of the agreement that we're signing, that they got good and valuable consideration. This is in their best interest. They're fully informed and not confused. Satisfied with the sales price. The sale will be final. Contingencies may exist. That we're not giving them a loan. It's an agreement. Maybe that this option may be assigned. That there is no escrow. It talks about the closing documents, copies of the paperwork. I mean, it just goes on and on and on. They're advised they have the right to legal counsel, financial review. That it was fairly negotiated. No other promises made, and that they fully satisfied with the agreement. And there again, like I said, it's signed and notarized. So we don't want someone coming back saying, "Well, they took advantage of me," or they didn't explain that to me. We want everything fully disclosed, fully signed off on, and notarized, so that there's no questions. So that's pretty much the documents with doing an option. Once again, remember, the option is your number one tool that we are going to use as investors. The notice of option is the most powerful piece of paper because it gives us the legal right to do what we do. So I hope that explains how we do options. Thank you.